Hello, everybody. This is for the week of April 27th through May 1st, our last week. This is part two. We looked at judicial politics last time, the way that various religious interest groups get involved in litigation, and in some cases arrive in the U.S. Supreme Court. We talked about the various interpretations that people have of how law should relate to religion or not. So there's the separationists on one hand and the accommodationists on the other, and the way that most laws, most rulings in the Supreme Court anyway, kind of come down somewhere in between depending on the issue. So we talked about, the early strict separation cases and how the court modified that later with the Lemon test to try to balance the interests of religion and secular society. Then we looked at the free exercise cases. So let's look at some of those cases today and consider their actual arguments, starting, of course, with the first one, Mormon polygamy. We've said a lot about this already. It was a major obsession through the 19th century. After the Mormons left upstate New York and relocated out in Utah, around Salt Lake City, where large numbers of them are still today, this obsession about Mormonism and this practice of polygamy was everywhere in mainstream American society. And it was really demonized and looked upon as very suspicious. Well, Civil War comes and goes. We enter the Reconstruction era and the Gilded Age, and around about the 1880s, the state of Utah, which had been a territory all this time, largely self-governing, wanted to join the Union. And the Union wanted Utah. There's big mining industry out there. There's a lot of good stuff in Utah for the American Union. But of course, the big dilemma for Ulysses Grant early on was, can we admit them when Mormons practice polygamy? So there's Brigham Young, the successor to Joseph Smith, with his long line of wives. What to do about this? Well, the policy was, and Congress let Utah know, you have to abolish this practice if you want us to accept your state into the Union. In open defiance, though, Brigham Young's secretary married his second wife. Of course, a lot of men in this part of Utah had several wives already, but he did it specifically to make a point. And that was, of course, George Reynolds. Reynolds right away was able to appeal this to the federal courts. Can Congress mandate that men in this territory only have one wife or face criminal penalties? Doesn't that openly violate the free exercise clause of the First Amendment? So here we have the first ever challenge to federal law based on the religion clauses, or really just about any part of the Bill of Rights. Remember, the Bill of Rights did not yet apply directly to states because the 14th Amendment hadn't yet been interpreted as incorporating them. But this was a federal law. And so this is one of those few instances when clearly there was a case here under the Bill of Rights. It did apply directly to individual citizens because they were living in a federal territory and it was a federal law. The case has a double purpose to it. On one hand, to define what is acceptable in terms of free exercise of religion, assuming, of course, that this would not come up again. Morrison Waite, the Chief Justice at the time, did not foresee the coming of the incorporation doctrine. The other question is, of course, to define the meaning of marriage. That's the real looming issue here. What is marriage, and what does polygamy mean if marriage is a fundamental institution for all of society? If we allow polygamous marriages, what does that mean for American liberty? So, two questions to answer here. Let's look at the case. On page 56 and 57, he points out, as it existed for the Latter-day Saints, the duty to marry multiple wives was a duty. It was, you faced serious penalties within the church if you didn't. And so to have multiple wives was an essential part of what it meant to be a Mormon at this time. Reynolds had already gone through a criminal trial, and they tried very hard in that trial in front of the grand jury to say that Reynolds had criminal intent, as did all the men in Utah Territory who took multiple wives. Now, that wasn't entirely off base if you consider how a lot of the wives were underage, so there was some criminal intent there, but okay, those aside, what about the ones who weren't underage and they did it with the full consent of adults who were not minors? Does that have criminal intent? And so on that basis, Reynolds appealed it again, this time to the federal courts, to challenge the ruling in the lower court. The question is this, on page 58, according to Morrison Waite, that's Waite on the left, On the right, that's Reynolds. But yeah, what does Waite say? Upon this charge, he says, and refusal to charge the question is raised whether religious belief can be accepted as a justification of an overt act made criminal by the law of the land. The inquiry is not as to the power of Congress to prescribe criminal laws for the territories, but as to the guilt of one who knowingly violates a law, right? So that's the real question here, which has been properly enacted. If he entertains a religious belief that the law is wrong. Now, can his religious belief say that this law is wrong and then claim protection under the Free Exercise Clause of the First Amendment? He says, Congress cannot pass law for the government of the territories which shall prohibit the free exercise of religion. Sure, that goes without saying. So there's not going to be any federal laws in the territories that go against someone's free exercise. But, first question, can we really consider this a religion? Or maybe Mormonism is, okay, fine. But can we consider polygamy a fundamental aspect of a religion, the duty to take multiple wives? He points out it's tricky because the word religion is not defined anywhere in the Constitution. It's only mentioned a couple of times, no religious test for office, and things like that. And then, of course, the First Amendment. But that's it. And so we have to really think about what it meant when the Constitution was adopted. At the time, there were established state churches back in the colonial era. And we've gone all over this before. He kind of gives us a history lesson again, though. And they prescribed doctrines and precepts, and they would tax people who didn't agree with them or worshiped in some different way. General taxes would be collected to support established state churches until the state of Virginia in 1784 disestablished religion for the first time under the guidance of Thomas Jefferson and James Madison. And we talked about all that before. He quotes the Memorial and Remonstrance here, and he talks about the way Jefferson understood what he was doing. Does this mean, though, if you consider the record of the Constitutional Convention, or if you consider the record of the Virginia debates and Thomas Jefferson's role in it, does this mean that free exercise can protect something like polygamy? It was pretty clear, according to Waite, that Jefferson understood that free exercise wasn't its own thing. It wasn't an absolute right. No, it was a right that had to be conducive to something bigger than itself, and he calls that good order. The right ordering of society. And there's evidence of this in the writings of the founders, that free exercise wasn't just the right to believe and worship any way you wanted. Sure, I mean, there's a broad array of things you can believe and ways you can worship, but no, it existed for the sake of good order. So Waite says at the bottom of page 59, coming as this does from the acknowledged leader of the advocates of the measure, it may be accepted almost as an authoritative declaration of the scope and effect of the amendment thus secured. Congress was deprived of all legislative power over mere opinion, right? But it was left free to reach actions which were in violation of social duties subversive of good order. Congress can legislate on those things, and presumably so can the states. All right, let's take polygamy. Is polygamy subversive of good order? And here he makes his transition away from the religious question to the question of marriage. It's a tricky thing to research in this era, 19th century. It's hard to figure out exactly what people thought marriage was. I think for most Americans, it was just such a self-evident thing. No one had to stop and examine what marriage as an institution actually was and what it meant for civilization. But here's one of those rare glimpses into what it actually meant when you contrast marriage as Waite understands it, as mainstream American society understands it, with Mormon polygamy. He points out, for James I of England, it was punishable by death to take on a second spouse. And that law was carried over into all the colonies. Of course, it never happened, so it's not enforced anywhere. Even as Virginia disestablished religion, Virginia kept this same old law from James I of England, that indeed polygamy is punishable by death. Wow, that's serious. Why, though? Well, it's because polygamy undermines the kind of social order you need for freedom. So in one of these cases, and we'll see these in the other two cases as well, the real question at issue here is, what is the fundamental order of society? What is the shape of culture? Very much like we talked about last week. So here Waite says, page 60, a little below the middle, from that day to this, we think it may safely be said that there never has been a time in any state of the Union where polygamy has not been an offense against society. cognizable by the civil courts, and punishable with more or less severity. In the face of all this evidence, it is impossible to believe that the constitutional guarantee of religious freedom was intended to prohibit legislation in respect to this most important feature of social life. Now, you can't mess with marriage, and legislatures and even Congress at the highest level are within their rights to protect it. Marriage, while from its very nature a sacred obligation, is nevertheless in most civilized nations a civil contract, but usually regulated by law. Upon it, society may be said to be built, and out of its fruits spring social relations and social obligations and duties, with which government is necessarily required to deal. So, marriage is the first institution, presumably along with religion, but as far as law is concerned, no, it matters how marriage is, and the character of marriage and the understanding of what marital obligations are determines everything else about that kind of society. We have a free society, we have liberty. And because of that, it's vital that marriage be attuned to the needs of liberty. And it's widely assumed that the only kind of marital arrangement conducive to liberty is one man, one woman, not multiple partners in a polygamous relationship. He points out, he looks at some anthropology here. Professor Lieber points out that polygamy leads to the patriarchal principle, and which, applied to large communities, fetters the people in a stationary despotism, while that principle cannot long exist in connection with monogamy. So yeah, polygamy is a foundational arrangement for tyranny. We can't allow it for that reason in the United States. Chancellor Kent, one of the great commentators on common law, observes that this remark is equally striking and profound. An exceptional colony of polygamists under an exceptional leader may sometimes exist for a time without appearing to disturb the social condition of the people surrounding it, but what's happening now, the Mormons of Utah want to become part of the national union. So for that reason, they're no longer an obscure colony out in the Salt Lake. They're going to be one of our states, and they must comply with the expectations of American society for that reason. So in conclusion, criminal law and the laws of a state legislature, they govern society for a reason. They have a clear idea about what sort of marital arrangement is necessary for freedom. And so for that reason, we can't allow any departure from that. Here's a hypothetical here. Suppose one believes that human sacrifices were a necessary part of religious worship. Would it be seriously contended that the civil government under which he lived could not interfere to prevent the sacrifice? Or if a wife religiously believed it was her duty to burn herself upon the funeral pile of her dead husband, that's of course the ancient Hindu practice of suti, which the British Empire at this time was having to deal with. Do you allow it, or do you ban it as imperialists? What do? Wade had obviously heard about that. So here he says, as a law of the organization of society under the exclusive dominion of the United States, it's provided that plural marriages shall not be allowed. If we were to allow this, Waite says, then that means every individual would be, he says, a law unto himself, and government would exist only in name. So, sorry Mormons, polygamy is not protected under the First Amendment. And so soon after, you had the Manifesto of 1890, a few years later, where the Latter-day Saints finally decided once and for all, as the church, that no, they would no longer recognize polygamous marriages. One of their leaders received a message from God saying that no, this was a mistake, this was never supposed to happen. And so the Latter-day Saints no longer recognized it, and Utah came into the Union. It's still practiced, as we've heard, and we talked about this earlier, among more fundamentalist versions of Mormons in remote parts of Utah, but it's not formally recognized by the state. And indeed, there have been quite a few criminal investigations of people like Warren Jeffs, who are supposedly taking on underage wives. But the official line is no, polygamy can't be accepted. Still, it's a remarkable case because it really shows you, like we said, a glimpse of what people actually thought about marriage at this time and what it meant for civil society and what it had to be. Consider right after the Civil War, with all the freed slaves, one of their number one interests was to be married, right? Because that's something you couldn't have guaranteed living in slavery. Some slave owners would, but others wouldn't. It was all up to the slave owner. to decide what was marriage. Now, to have a marriage that was protected under civil law, that was perceived as one of the most important things associated with freedom, along with education and property rights. So, yeah, really interesting question. And it raises the question today as we see the changing nature of marriage. Is it really that fundamental of an institution? Or isn't it just kind of up to individual people? Maybe the more fundamental institution is not the marriage, but the state. And each of us is an individual under the state, and each of us receives a right to marry from the state, whoever we choose, and most recently, regardless of gender. So, is that true? Can we really understand civilization from the top down in such a way? Or is Waite right? It's still bottom up. The public reaction to this was striking. George Cannon, who was the representative from the territory, so he was a non-voting member of Congress, who sort of represented the territory. He himself was a Mormon, and he had this to say to the media: "Our crime has been this. We married women instead of seducing them. We reared children instead of destroying them. We desire to exclude from the land prostitution, bastardy, and infanticide. And aren't those things you see everywhere else in the Union? Even in places where marriage is understood as one man, one woman?" He said, "Let it be punished in the four corners of the earth, that in this land," published in the four corners, "that this land of liberty, the most blessed and glorious upon which the sun shines, the law is swiftly invoking to punish religion, but justice goes limping and blindfolded in pursuit of crime." So, those are the Mormons of the old days. What about the Jehovah's Witnesses, though? They are perceived as a similar in kind of the roadmap of American religion. Where do they come from? The Jehovah's Witnesses came out of the Seventh-day Adventist tradition, and a lot of these more splinter groups actually did. William Miller emphasized the imminent second coming of Christ, and so he really started the whole movement toward this end times apocalypticism that became very common among fundamentalists later. But out of that group came the Jehovah's Witnesses, who initially just called themselves Bible students, and they were all followers of this guy, Joseph Rutherford. And Rutherford ran the Watchtower Society from the top down. And he was something of a dictator by all accounts. He took complete control of the organization. He had really, really close surveillance of what everyone was doing. And he taught, too, that there's only one God, Jehovah God. Is he three in one, the way that conventional Christians understand the Trinity? No, he's one simply. That's what Jehovah means, like the oneness of God, even in the Hebrew tradition. And that is the only God that we should worship. The Trinity is like polytheism. It's three gods. It's nonsense. And he really insisted on this very stripped down understanding of theism. And he insisted, too, that Jehovah's Witnesses should not participate in the mainstream aspects of American life. Among them, patriotic things like saluting to the flag and a number of other things. They don't vote. They don't enlist in the military. They live in these sort of quiet, insular lives, not directly involved with politics or anything. But one thing they were always very good at and quite aggressive about was their proselytizing, especially with the Watchtower Society magazine, the official magazine of the Jehovah's Witnesses. And they would aggressively go after mainstream Christians and their beliefs. And in doing this, they brought down a lot of violence upon themselves. Jehovah's Witnesses got pretty beaten up for this kind of, on one hand, insular, at the same time, sort of aggressive style of evangelism. There were quite a few German Jehovah's Witnesses as Nazi Germany came to power, and they ended up in concentration camps with a lot of other people like Jews and Gypsies. It was mostly Jews, but there were Jehovah's Witnesses there too, because they would not pledge that degree of allegiance to Hitler's Germany. You can still see Watchtower headquarters today, by the way, in Brooklyn, right across from New York, and the big sign still stands out front, and it operates very much the same way it always has, printing the Watchtower magazines, and you see Jehovah's Witnesses distributing them in public parks, pretty much all over the place, especially in the summer. Well, 1940 is here, and it really looks like the United States will get pulled into World War II one way or another. There's a strong isolationist movement, a lot of people insisting that we should do everything we can to keep out, and Franklin Roosevelt is promising he'll do his best in fireside chats, saying how much he despises war, but we don't know what's going to happen. We might end up involved in Europe's problems. We shall see. Remember, we weren't formally involved until December of 1941, the following year after Pearl Harbor. But prior to that time, patriotic feeling got really intense, and you saw in public school classrooms all across the land the Bellamy salute. We talked about this earlier, the stiff-armed salute, technically with the palm pointed up, though some kids preferred to point it down, knowing full well that this looked very much like what Hitler's Nazis were doing. But hey, we're Americans. It's different. It's the flag. It's not the Fuhrer. It's not Nazism. But what did Jehovah's Witnesses think about this? Well, they don't have any patriotic feelings at all about anything, let alone saluting the flag this way. And finally, it happened in the little town of Minersville, Pennsylvania. The Gobitis kids got in trouble because they refused to stand and salute the flag. And it was this big classroom disruption. And Lillian and Billy were escorted out of the classroom into the principal's office, and they faced big, big trouble because in the state at the time, there was a law that required all students to stand and say the pledge to the flag. This was patriotism running wild in the state legislatures. They were expelled. They had to go to a private school that would accommodate them doing that, and their dad had to dish out the tuition. This was a significant harm to him and his family. And so he found an attorney who would do pro bono work and appealed it to the U.S. Supreme Court. What did the court decide? The opinion was written by Felix Frankfurter, a justice on the court who had a very interesting background. He was probably, I think, the third Jew ever on the court. The first one was Louis Brandeis. The other one was Benjamin Cardozo, and then came Frankfurter. He was in a different situation, though, because he was an immigrant, too. So he had come from Austria in the late 1920s, and by the end of the 1930s, Austria, remember, had been annexed, along with Czechoslovakia, into the Nazi regime. Several of his Jewish relatives disappeared. He knows what's going on over there in 1940. The fact that he would write an opinion like this is really surprising. Because does he come down on the side of religious liberty for the Jehovah's Witnesses? No. He points out, though, you can really hear the tension in his writing, thinking about his own Jewish heritage, thinking about what's happening to his own people over in Europe. He says, this is a grave responsibility that confronts the court. It's a grave responsibility whenever in course of litigation it must reconcile the conflicting claims of liberty on one hand and authority on the other. He summarizes the facts. The kids stand and say the Pledge of Allegiance. The Jehovah's Witnesses refuse. They believe that the flag is idolatry. They are forbidden from saying a pledge to it, and for this they got in big trouble. The school attendance, though, is required, and so their dad had to send them to another school. What's at stake here in the Constitution? It is, of course, the First Amendment free exercise clause. But notice how he puts it. Why does it apply to these kids in the state of Pennsylvania? Because it is, he says on page 136, absorbed by the 14th Amendment. There is the incorporation doctrine we talked about before. So you take the case of the Mormons, they had a direct appeal to the Bill of Rights because it was a federal law directly affecting them. Now, the 14th Amendment has incorporated the First Amendment. That free exercise clause applies to every individual citizen to the point where they can sue their state, which is exactly what happened here. And so we have to decide the question of conscience. Does the free exercise clause protect individual conscience? He says on page 136 in the middle, certainly the affirmative pursuit of one's convictions about the ultimate mystery of the universe and man's relation to it is placed beyond the reach of the law. Government may not interfere with organized or individual expression of belief or disbelief. Now, propagation of belief or even disbelief in the supernatural is protected, whether in churches or chapel, mosque or synagogue, tabernacle or meeting house. So yeah, the state can't mess with your religion. It cannot dictate how you worship. It can't tax you. All that is long gone with the First Amendment, now applied by the 14th. But this is a different situation because there's a secular interest here. These kids are in a public school. Now what? Public schools are extensions of the state. And for that reason, they have a very clear interest in determining what the kids learn, the formation of their intellects and their consciences around the common culture. There is where you must leave behind your religious beliefs. I mean, sure, keep them in your head, but they don't matter to the secular environment that you're in, because that is about the common good, not the individual good. The common good is Frankfurter's major concern here. Now, again, it's incredible that he's saying this, given what's happening in Nazi Germany. The fact that you're seeing the rise of totalitarianism, the common good, is skewed to be this evil thing, and it's coming down hard on his own fellow Jews. Doesn't matter. His concern is about the common good. To save the problem is to recall the truth that no single principle can answer all of life's complexities. The right to freedom of religious belief, however dissident and however obnoxious to the cherished beliefs of others, even of a majority, is itself the denial of an absolute. But to affirm that the freedom to follow conscience has no limits, no, we can't accept that. No limits in the life of society would deny the very plurality of principles, which, as a matter of history, underlies protection of religious toleration. Our present task, then, as so often is the case with the courts, is to reconcile these two rights, the rights of the individuals and the rights of society. How shall we do this? The bottom line is general legislation applies generally. Particular exemptions is up to the general legislation to decide, not the Supreme Court interpreting the First Amendment. He says on page 136, a little above the middle, the mere possession of religious convictions, which contradict the relevant concerns of political society, does not relieve the citizen from the discharge of political responsibilities. The necessity for this adjustment has again and again been recognized. In a number of situations, the exertion of political authority has been sustained, while basic considerations of religious freedom have been left inviolate. We've ruled this way many times, Frankfurter says. We often rule in favor of the general laws and the general public interest, unless there's a clear violation of individual conscience. But that is not the situation here. These kids are in a public school. They agree to the norms and standards of that school, and they must agree to the flag salute as well. What is at stake in the flag salute? He points out it's nothing less than our national unity. That is the basis of our whole society. And as he points out too, the basis of our national security. We have to all be on the same page when it comes to patriotism because our security is on the line here. He reminds us that this is an old question for democracy. It is one of the oldest and most profound questions going back to Socrates on trial for philosophizing in Athens. It's something, though, that Abraham Lincoln really addressed well during the Civil War. Lincoln, he said, cast the memorable dilemma this way. Must a government of necessity be too strong for the liberties of the people, or at the same time too weak to maintain its existence? So, you have to have a government that's strong enough to govern, or in this case, defend the Union against a rebellion. At the same time, you have to have a government that's able to accommodate individual rights. Can individual rights then trump completely those general interests in preserving the Union? What happens to individual rights if there is no Union, Lincoln asks. Of course, he's talking about suspension of the habeas corpus rights during the Civil War. Are there going to be any civil liberties or any habeas corpus rights if we're living in anarchy? No, Lincoln said. That's exactly my point, Frankfurter says. Someone might object. Look, the flag salute is not a function of the government, right? Okay, not giving secrets to spies. That makes sense. There's all kinds of things that are clearly in the interest of government, possibly in wartime, but not the flag salute. Come on. How does he reply to this on page 138? Government may not prescribe the flag salute, but it does presuppose the existence of an organized political society. The ultimate foundation of a free society is a binding tie of cohesive sentiment. Such a sentiment is fostered by all those agencies of the mind and spirit which may serve to gather up the traditions of the people, transmit them from one generation to the other, and thereby create the continuity of treasured common life, which constitutes civilization. What is that symbol that carries on that tradition? It's the flag. What else could it be, Frankfurter says. So again, yeah, maybe it's not in the interest of the government to mandate flag salutes, But it is in the interest of the government to have a unified culture, which in turn is what makes civilization possible. And the flag is the thing that makes that work. These were the state of Pennsylvania's reasons. They wanted to affirm the meaning of citizenship. They wanted to unify sentiment and love of the country around one common goal, especially at this time when we may very well be entering on a terrible war as World War II breaks out. The question before the court is whether or not the end is legitimate here. Maybe not the means. The means may indeed be ridiculous. They may be impulsive and unfair, making Jehovah's Witness kids say the pledge or they're kicked out of school. Yeah, that seems crazy. But the end is legitimate. That is what the state is after, is unifying sentiment. Someone else might object. Can't you have an exemption? Can't the state carve out an exemption for kids like these, or Jehovah's Witnesses as a group, that says that they don't have to say the Pledge of Allegiance? Sure, Frankfurter says, but that's not the court's job to force the state to carve out an exemption. We're not here to create exemptions. The courtroom is not a board of education, he reminds everybody. We're not the school board of the country on page 139. No, that authority has not been given to this court, nor do we assume it. It is up to the states. We recommend that they carve out exemptions, but we cannot make them do it on the basis of the First Amendment. Besides, the force involved here is not that harsh. Parents can opt out of public education and send their kids to private schools. Of course, the question he doesn't consider there is, do they have to pay for it? Here's a case for vouchers, like we talked about last time in school choice, but that wasn't really on the table in 1940. He points out too, look, is there anything in this law that requires parents to go along with what the school district is saying? No, the kids can come home and Mr. Gobaitis can lay out for them how wrong this is that they have to say the Pledge of Allegiance and it's an idol and the whole thing. Yet there's nothing in the law that prevents him from doing that, and so there's no real threat to his religious freedom. And so the law is upheld. We have to put things in right order, Frankfurter says. It is not from individual religious freedom that you get civil society. It's the other way around, he says on page 140. It's the ordered society, especially the one that reveres its flag, which in turn is allowed to grant individual freedoms. The social order comes first, Frankfurter says. Individual freedoms come second. You cannot have a civil society otherwise. Is the state legislature making a terrible mistake here? Maybe so, but our job is to let them make it. And if the Jehovah's Witnesses want to petition the state legislature, if they want to arouse the sympathy of their fellow citizens for their plight, they are perfectly within their rights to do that. And we will protect their free speech and we will protect their freedom of the press. But we're not going to force the state legislature to accommodate them. So it is resolved. The following year, 1941 comes around and things are getting more intense overseas. The state of West Virginia takes the Gobaitis case and says, wow, here is a justification from the Supreme Court for what we want to do in our state. We want to mandate the flag salute. And we're going to ratchet it up a bit. If kids don't say the Pledge of Allegiance, they will be expelled. Then their parents will be charged with truancy and face day after day in jail until they recant and send their kids back to the school and they say the Pledge of Allegiance. Whoa, that is really heavy-handed. That's way worse than the Pennsylvania law was. What to do about this problem? The pledge itself was part of a much broader civics curriculum that was focused on Americanism and inspiring patriotism in all the students. So the flag salute was only a small part of that. But you can tell it was really heavy-handed, and indeed much of the law was aimed directly at anybody who dissented, even for religious reasons. There's nothing to indicate that the statute targeted Jehovah's Witnesses, but it was definitely aimed at people like them. Although a lot of the parents on the school boards took a serious look at the Bellamy salute and said, you know, the stiff arm salute is a bit much. It does indeed look like what Hitler and the Nazis are doing. How about hand over the heart, and you just keep it there all the way through the pledge? So they dropped the old Bellamy salute, but still the pledge went the same. Remember too, this is 1941. This is before we had the under God line inserted in the Pledge of Allegiance. Remember, that was under Dwight Eisenhower's administration later in 1957. So it was still at this point a deeply nationalistic, very patriotic thing that didn't have any kind of spirituality to it. That all came later. And so, once again, the Barnett family, appeals it up to the U.S. Supreme Court. They don't get any public attention. We don't really know who the Barnett kids were, or even if that's their real name. But they got an attorney, and they appealed it to the Supreme Court in hopes that the court would reconsider the Gobitis decision from the previous year, specifically because the state of West Virginia found this as justification for this extremely heavy-handed law. Well, immediately the court decides to hear the case, and Justice Robert Jackson writes the opinion of the court. And he does a dramatic about-face from what Felix Frankfurter had written the previous year in the Gobitis case. He points out the Jehovah's Witnesses have a very specific scriptural mandate to not say the Pledge of Allegiance. It's in Exodus chapter 20. Thou shalt have no graven images, it says in the Ten Commandments, or any likeness of anything that is in heaven above, or that is in the earth beneath, or that is in the water under the earth. On and on it goes. And they consider the flag to be one of those things. The penalties are so harsh, Jackson says, for this. We are plainly putting these kids in a horrible situation. And so, as it happens once in a while in the U.S. Supreme Court, we have to reconsider a previous decision. And so they did. And they overturned the Gobitis decision. Why? Here, Jackson is very systematic. He's widely regarded as one of the best writers and most persuasive attorneys on the U.S. Supreme Court because he's so systematic about everything. He takes apart point by point the ruling in Gobitis. No hard feelings against his fellow Justice Felix Frankfurter, but he was wrong. You just have to say. So the first point, he takes the claim in Gobitis that the public good is greater than the individual good. And that's kind of the underlying point of that whole case. And Frankfurter wholeheartedly believed it. And he quotes Gobitis, saying exactly that. And he quotes the quote of Abraham Lincoln, asking, must government be too strong for the liberties or too weak to maintain its own existence? He points out, well, first of all, what was Lincoln talking about there? He wasn't talking about religious freedom. He was talking about habeas corpus rights. Remember, because Lincoln had suspended habeas corpus unilaterally to prevent sabotage against the war effort during the Civil War. That's nothing like free exercise, Jackson says. Free exercise is a harmless right in the face of government power, even in the most extreme wartime. All they're doing is just sitting down while the other kids stand and say the Pledge of Allegiance. What's the big deal? Respecting religious rights, Jackson points out, does not make government weak. If anything, it makes it stronger. Individual rights are the whole duty of that government. And shouldn't we see that most clearly in this age of rising totalitarianism like we see over in Europe? Second point, Frankfurter was concerned that the court would become the school board of the country if it got involved with this case. That's not true at all, says Jackson. How does he reply? Civic education is all about, certainly, patriotism and our Constitution. It's also about respecting rights. Isn't that the best kind of unifying thing that you can offer? If a school board decides to have people respect individual rights, maybe the best example they can give is, notice your Jehovah's Witness classmate friends didn't say the Pledge of Allegiance. We respect their right to do that. That's American freedom. Isn't that what they should say, Jackson says? All are subjects to the Constitution, after all. It is the law of the land, and that includes not only its powers, but its rights. And among those is the free exercise of religion, and the right to refuse to say the Pledge of Allegiance. His third point, legislation can protect individual rights. And remember, Frankfurter said that, saying that there should be an exemption. The court is not going to force the state to have an exemption, but there ought to be an exemption, and it's up to the state legislatures to do that. No, says Jackson. You can't trust legislatures to do that. I mean, good for them if they do, but they're not the kind of bodies that are concerned about protecting individual rights. The Supreme Court is. The court, because that's a matter of interpretation. And legislatures don't interpret, they just make law. Courts interpret. So he says on page 143 toward the bottom, the very purpose of the Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy political controversy, and to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied only by the courts. So that means one's right to life, liberty, property, free speech, free press, and freedom of worship and assembly, and other fundamental rights may not be submitted to a vote. They depend on the outcome of no elections. So right there you see the first glimmer of the kind of fundamental rights jurisprudence that the court is going to pick up in later years. And Jackson was right on board with that. We mentioned the rights revolution last time, starting with civil rights and then free speech and then reproductive rights later. That's all based on that very same idea that democracy is great. Democracy can do all kinds of wonderful things. Checks and balances works fine in terms of limiting power. But at the end of the day, you have to have certain fundamental rights that are not subject to vote, that are not subject to political controversy or democracy. It's only when you have those rights protected by courts that democracy even works. So that is very much the assumption we see in the court in recent history and today, that it exists to protect fundamental, untouchable rights. His fourth point, and he says this is kind of the main point of the Gobitis decision, that national unity is fundamental, that national unity is the basis of national security, on page 144 toward the bottom. Okay, maybe so, but do you establish that unity by force? If that's the case, then the greatest threat to national security is the very government that's forcing people to conform. We become the very monster that we're fighting. We become like totalitarian regimes, don't we? He says on page 145, a little below the top, probably no deeper division of our people could proceed from any provocation than from finding it necessary to choose what doctrine and whose program public education officials shall compel youth to unite in embracing. You know, whose values is it going to be? Whose patriotism is it going to be? No, we cannot allow state legislatures or school boards or anybody to be that abusive. He says in the next paragraph, it seems trite, but necessary to say that the First Amendment to our Constitution was designed to avoid these ends by avoiding the beginnings. There is no mysticism in the American concept of the state, or of the nature of the origin of its authority. No, we set up government by the consent of the governed. And they only come at the social contract and that national unity, assuming that their individual rights will be protected. He sounds very much like John Locke here, if you've read John Locke. That's his point. But what about patriotism, though? Don't we need patriotism in these dire times? No. To believe that patriotism will not flourish if patriotic ceremonies are voluntary and spontaneous instead of compulsory and routine, that is to make an unflattering estimate of the appeal to our institutions to free minds. And what is the value of our free institutions anyway, if they have to compel us to respect them? And then comes the famous line where he sums it all up. If there is any fixed star in our constitutional constellation, it is that no official high or petty can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. If there are any circumstances that are an exception to this rule, we don't see it now. What a line, though. If there's any fixed star in our constitutional constellation, if there's only one thing that matters at the end of the day, it is that no official, high or petty, can force someone to believe something they don't believe. So, what do you make of this case? You really see glimmers, like we said, of a lot of the civil liberties cases that come down in later years, dealing with all kinds of issues, not just religion, but everything. Well, it so happens Felix Frankfurter dissented. The book didn't include his dissent, but it's quite stunning. Here's just the opening line. One who belongs to the most vilified and persecuted minority in history, being a Jew, as he was, is not likely to be insensible to the freedoms and guarantees of our Constitution. I feel for these Jehovah's Witness kids. I didn't mean to dismiss them, Frankfurter says. Were my purely personal attitude relevant, I should wholeheartedly associate myself with these libertarian views espoused by Jackson and the majority of the court. But, as judges, we are neither Jew nor Gentile, neither Catholic nor agnostic, summarizing a passage from the Bible there in Hebrews. We owe equal attachment to the Constitution and are equally bound by our judicial obligations, whether we derive our citizenship from the earliest or the latest immigrants on these shores. I stand by what I said and go Bitus, he says. This is wrongly decided. I feel for these kids. I wish the state would carve out an exemption for them, but the court does not exist to force states to comply with its interpretation of individual rights. So, what a debate between these two. They sparred on a lot of things on the court. It was one of the major disagreements that came up between them. Jackson, on one hand, sees civil society as resting on individual rights. Frankfurter sees civil society resting on tradition, which in turn protects individual rights. So in that way, if you want to go back to political philosophers, Jackson is more like John Locke, and to some extent, John Stuart Mill. Frankfurter is more like Edmund Burke, right? So is it rights abstractly understood that are the foundation of civil society, in which we bring with us expecting them to be protected when we join the social contract? Or is it traditions and ancestral customs and patriotic ideas, which in turn allow us to enjoy those rights, as Frankfurter says? Wonderful debate. I'll be interested to hear your thoughts on that question. Fast forward to the early 1960s, and yet another example of group unifying activities in public schools, school prayer. School prayer was a really old tradition. Notice these are public schools, right? These are public taxpayer-funded schools. It was a really old tradition in these schools going back to the earliest days of public education, because it was just such a part of the rhythm of life of mainstream Protestant society. Of course, the conspicuous thing about this, if you look at the history of it back in the late 19th century, they made it an explicitly Protestant style of prayer. The Catholic kids had to pray along. They weren't allowed to pray their rosary. Sometimes there were exceptions, but again, it was always up to the states and the school boards to decide this question. School prayer, though, by the 1960s, it was just part of the rhythm of life. It's just what you did at school. It's part of the opening day. You say the Pledge of Allegiance, then you pray. And the prayers were, by the 60s, more and more generic, more and more accommodating to a diversity of views. And so in the early days, they would have been more explicitly Protestant Christian. By this time, though, they're just kind of generic. They refer to God in a civil religion kind of sense. We invoke your blessings on our day and on our teachers. You see Hugo Black quoted in the opinion. And they're just the norm. They've been there for years. And all of a sudden, there's a lawsuit. Well, the other two cases dealt with the free exercise of religion. This one deals with the opposite. It deals with establishment, which is interesting because a lot of the people involved, the teachers, the kids, the superintendents, they thought, well, this is free exercise, right? I mean, all the kids want to pray. If they don't, okay, they just stand there quietly and let their fellow classmates pray. It's free exercise, right? No, said the petitioners who brought suit against the school district. It's coerced. It's not coerced. No, it is. And it violates the Establishment Clause, not the Free Exercise Clause, but the Establishment Clause of the First Amendment, the part of the Constitution that says Congress shall make no law respecting an establishment of religion. Congress, says the school board? That's like the federal legislature. We're the school board. Yeah, but notice the court has increasingly turned to the 14th Amendment to incorporate the Bill of Rights. So it's not about Congress anymore. It's about the rights themselves as they apply directly to the states. We've already seen it with the Free Exercise Clause. We've seen it with other things like free speech and freedom of assembly. So too, we see it with non-establishment. And because this is a taxpayer-funded public school and these kids are praying, you're violating the Establishment Clause. And so the case moves forward and it appeals up to the U.S. Supreme Court. And who writes the opinion but Justice Hugo Black? We talked about Black before. Remember, he was the one who, first of all, was a Ku Klux Klan member back in the day. And when President Roosevelt appointed him, Roosevelt said he didn't know that. He probably didn't. Black, though, right away renounced his Klan membership, said he didn't have anything to do with it anymore. And by all accounts, by the 1960s, he actually had. So the real concern with Black was the fact that when it came to the Supreme Court anyway, he was the one who introduced for the first time the phrase separation of church and state, or the wall separating church and state, as a formula for interpreting the Establishment Clause of the First Amendment. Now, again, the Constitution does not say anything about separation of church and state. It doesn't say anything about a wall. But for Black, this was sort of a clear formula for interpreting what the Establishment Clause actually meant. So here's Black in Engel v. Vitale, the school prayer case from 1962. He lays out the facts. He summarizes the prayer, the fact that it's very generic and unoffensive. But he says the petitioner objects on the basis of the First Amendment applied through the 14th Amendment. What to do about this? Well, we rule that prayer is indeed wholly inconsistent with the Establishment Clause on page 200, a little above the middle. There can, of course, be no doubt that New York's program, came out of New York, the program of daily classroom invocation of God's blessings, as prescribed by the Regent's Prayer, is religious activity. Of course it is. Prayer is always religious. Everyone knows that. In fact, they even admitted it. And here he quotes the testimony. The religious nature of prayer was recognized by Jefferson, has been concurred in by theological writers, the United States Supreme Court and state courts, and administrative officials, including New York's Commissioner of Education. We all know it's religious. We all admit it. The court agrees, yes, it is religious. You're right about that, and that's why we have to strike it down. It must not stand. Why? And here Black does his usual thing. If you read his other opinions, he's big on this. He gives you a history lesson. Let's go back to the beginning. Let's go back to colonial times. Why did so many settlers come to the New World, whether it was Puritans in New England or any number of groups up and down the East Coast? It was to get away from the Church of England. Sure, some came to get rich and a variety of other reasons, but the religious ones, though, came to get away from the Church of England because they had a mandated Book of Common Prayer. That's, even to this day, that's the main prayer book for the Anglican Church, the Church of England. And it was mandated in England that everybody pray the same prayers in the Book of Common Prayer. And this caused all kinds of disputes between different sects within the Church of England, between different Christians who didn't want to go along with the Church of England's way. All the fights over the Book of Common Prayer. It was the Americans, though, who came to the colonies to get away from that. Now, true, he points out, a lot of them turned around and established their own churches that turned out to be just as strict as the Church of England had been, but still, they were going in the right direction. The glorious moment came, though, we mentioned it already, in the state of Virginia, when the bill for establishing religious freedom was submitted by Thomas Jefferson, and Patrick Henry's bill was opposed by James Madison. Now we get it. Now we see what gets rid of all the religious animosity in society, all the fights over the Book of Common Prayer, all the fights within the colonies over who will have the established church and who's going to be taxed for not joining. All of that is neutralized in the state of Virginia, once and for all, with the disestablishment of religion. Notice, though, for Black, we talked about disestablishment before, and it was just that there would be no official church and that everybody would be protected in their own worship. Black takes it a step further, though. He says, no. What the bill for disestablishing religion was a step toward secularism. It was a way of getting religion away from politics and government. Because what happens when religious groups get a hold of political power? They use it against other religious groups. They use it to push their values on society. And we just can't have that. And the First Amendment clearly does not allow such a thing. These were all of the reasons that went into the Establishment Clause as we finally received it in the Constitution. The Constitution itself doesn't really say much about religion prior to the Bill of Rights, but that's why it was ratified. That's why it was so popular, according to Black. Once the Bill of Rights was added, though, the First Amendment had this intention on page 202. It was added to the Constitution to stand as a guarantee that neither the power nor the prestige of the federal government would be used to control, support, or influence the kinds of prayer the American people can say, that the people's religions must not be subjected to the pressures of government for change each time a new political administration is elected to office. He doesn't say much here about the fact that the Bill of Rights was a compromise with anti-federalists. Black reads his history a bit selectively. So, all that said, let's turn to the New York law that mandates school prayer for all the kids. It is plainly unconstitutional under the First Amendment. True, some kids are allowed to remain silent or be excused from the room, but that doesn't matter, according to Black. The fact that it is a state decision makes it coercive. There's kind of a peer pressure that goes on among groups of kids. He says on page 203 at the top, when the power, prestige, and financial support of government is placed behind a particular religious belief, the indirect coercive pressure upon religious minorities to conform to the prevailing officially approved religion is plain. Sure, they might leave the room, they might sit silently, but the feeling of shame heaped on them, that they're not part of the group, they're not part of the whole, is very, very clear. And this is especially true in a public school classroom, Black points out. We talked about Levi Weissman last time, and we didn't read the case, but that was the case that had to do with prayer at a graduation ceremony. Anthony Kennedy's opinion is based very much on Black's reasoning here. The ostracism factor, the peer pressure factor. And Kennedy, though, says we've got a lot of modern psychology now to back this up, which Black didn't have at the time. He goes on, though. What is the purpose of the amendment? The First Amendment? Again, not a compromise with anti-federalists, not really even the protection of free exercise, but above all, what? Its first and most immediate purpose rested on the belief that a union of government and religion tends to destroy government and degrade religion. They do best when they are kept in their separate spheres. That religion, he says, a few lines down, is too personal, too sacred, and too holy to permit its unhallowed perversion by the civil magistrate. At the same time, government is too serious, it's too secular and rational to be corrupted by religion. And above all, it is meant to prevent persecution. Persecutions that have happened throughout history, especially because of religion. The First Amendment gets religion out of the government business so that government can govern in a rational way and not persecute anyone. Look at the examples. The Act of Uniformity for the Church of England that backed up the Book of Common Prayer, the persecution of people like John Bunyan, and all kinds of people who just wanted to believe the way they wanted to believe and not be bothered. Someone else might object. Does this sort of separationist reading of the Establishment Clause show hostility toward religion? Aren't you just being hostile toward religion, Black? Black says absolutely not. Religion is all about individual belief, and that is still protected by the Free Exercise Clause. Any reading of the Establishment Clause that was hostile toward religion would be wrong. No, separating church and state is not hostility toward religion. If anything, it protects religion from persecution. He says in the middle of 204, it is neither sacrilegious nor anti-religious to say that each separate government in this country should just stay out of the business of writing or sanctioning official prayers and leave that purely religious function to the people themselves and to those the people choose to look to for religious guidance. But what about the fact, though, that the prayer was inclusive, someone might object? The fact that it didn't say anything specifically religious. The fact that it was meant to be this generic show of free exercise for all the kids. And if they don't want to participate, fine. Doesn't matter, Black says. This is one slight step on our liberties. And here he quotes James Madison. You remember the line from Memorial and Remonstrance, that it is proper to take alarm at the first experiment with our liberties, that even the slightest breach of the wall of separation, a phrase that Black was fond of using, shows a serious threat, and the court exists to prevent that from happening. And so, school prayer is hereby struck down all across the land. There will be no more. The responses to this in the media were pretty hysterical. The Supreme Court lays out outlaws official school prayer. School prayer is now illegal. No, Black says it's not illegal. It's just not protected under the First Amendment. I mean, sure, you can go ahead and do it, but you're probably going to be sued because of this case. So, what do we make of this? Well, there was a dissent, and it came from none other than, well, yeah, a lot of the more public dissent as well, I should say, petitions all over the place, where you would sign, send it off for the Lest We Forget radio program and send it off to the Senate and Congress saying that we want prayer back in our schools. We want this religion back in our schools. And all these cards came flooding in to Congress at the time. Even to this day, there's consistent refusal to comply with the school prayer case. You probably heard of See You at the Pole, the sort of national network of Christian clubs at American university campuses who gather around the flagpole once a year and pray for their school. So what happens? The U.S. Marshals come swooping in to break up the prayer meeting and arrest the kids? No, it just, what are you going to do? The court can't enforce its own rulings. And so prayer has pretty much continued apace. The only thing you don't see, of course, is teacher-led prayer. That doesn't happen because of the litigation that can follow with the Ingleby Vitale precedent. But what about the dissent on the court? Potter Stewart bantered with Black a lot. He really did not like Black's theory of interpretation on just about anything. He was fond of pointing out that Black oversimplified the question. He treated the law like it was this just clear, crisp thing that you could present to the American public with no nuance and no complexity. Stewart didn't go along with that at all. Stewart was much bigger on the complexities that had to come with interpretation of law. And what did he say? A local school board in New York has provided that those pupils who wish to do so, right, he flips it around, may join in a brief prayer at the beginning of each school day. This is simply an exercise of free exercise. That's exactly what the school board said it was. There's no coercive pressure here. It's just, hey, let's pray if you want to. If not, then sit there and we'll be done in a second. That's all that's going on here. But no, the court strikes it down. There's no compulsion involved. No, it's entirely free, Stewart points out. But no, it's struck down. He points out how irrelevant the real history of our culture is to Black. Black looks at the history of the founding and the origins of the Establishment Clause, but he ignores all the subsequent history. What about how deeply ingrained into our society so much religion is? It's everywhere. Consider our Star-Spangled Banner. And the line which says, "Blessed with victory and peace, may the heaven-rescued land praise the power that hath made and preserved us as a nation. Then conquered we must trust when our cause is just, and thus be our motto, in God we trust." How about that? You want to ban that too, Black? He says. He looks at all kinds of other things. In God we trust, on our money. The National Prayer Breakfasts. This is 1962. John F. Kennedy had just attended the National Prayer Breakfast and observed the National Day of Prayer, sitting right next to Billy Graham. So come on, Black. There's so much more to the history of religion and society than just the Establishment Clause of the First Amendment. You can't just cut off the history there. Religion and politics have been deeply intertwined with each other to the point where we are a religious people whose institutions presuppose a supreme being, to quote an earlier case, Zorek v. Clausen. So Potter Stewart concludes, I do not believe that this court or the Congress or the president has, by any actions and practices I have mentioned, established an official religion in violation of the Constitution. No, there's no official religion here. This is all civil religion. It's inclusive. It's voluntary. I do not believe the state of New York has done so in this case either. What each has done has been to recognize and to follow the deeply entrenched and highly cherished spiritual traditions of our nation, traditions which come down to us from those from those who almost 200 years ago avowed their firm reliance on the protection of divine providence when they proclaimed the freedom and independence of this new brave world, or brave new world. So, who's right? Notice how both of them actually start from much the same place in the previous case. Think back to Frankfurter and Jackson. For Frankfurter, what held civil society together were the traditions and the common customs and the patriotic feelings. That was the source of unity. For Jackson, though, no, it was individual rights. Notice in this case, though, both Black and Stewart agree with Jackson. It's about individual rights. They just understand those rights very differently. For Black, those rights are fundamentally private and personal. Religious freedom is best when it is radically separate from secular authority. For Stewart, however, those individual rights are very much intertwined with the freedom to believe, the freedom to worship, the freedom to pursue religion according to the dictates of your conscience. And that means publicly. That means free exercise, which is exactly what the New York School Board said it was. So who's right? What do you think? Now, as we know, we talked about it last time, this was just the first case dealing with religion in school. Soon after came the Bible reading case, Abingdon v. Shemp. Soon after came the moment of silence case. Not even a moment of silence is permissible. And then a whole bunch of others, Levy, Weissman, the graduation ceremony, the one about the football game, the one about the Ten Commandments. It just goes wild with this strict separation rule. Well, what happens to free exercise at the end of this story? Let's turn to the question presented with peyote. What is peyote? It's a little cactus which grows predominantly in the Sonoran Desert, northern Mexico and parts of Texas and New Mexico. But it's spread up into the Pacific Northwest, and it is widely used by Native Americans. It's a powerful hallucinogenic drug, very much like LSD, and those who take it ingest it and have these profound spiritual experiences. And according to tradition, it's a very strict practice. It is absolutely not a party drug. You don't have fun on it. No, you have a religious experience. And for that reason, it's called sacramental, that it's a holy thing, and it's used exclusively for that purpose. That the Native American tribes who use it would never want anyone to get a hold of it and use it recreationally. They take it very seriously. So, what to do about peyote? Native American tribes have always had a unique relationship with the federal government. And in 1978, there was the American Indian Religious Freedom Act that explicitly protected Native Americans in all kinds of older traditional customs. Things like the sacred bundle, things like some of the dances that had been outlawed by the federal government. All that was finally let go of in 1978. But what about peyote? It says the listing of peyote as a controlled substance in Schedule 1, remember this is the war on drugs era after Richard Nixon, right? In Schedule 1 does not apply to the non-drug use of peyote in bona fide religious ceremonies of the Native American Church. And members of the Native American Church so using peyote are exempt. They are exempt from registration, right? So if you're on a reservation, you're on your own. Any person who manufactures peyote for or distributes peyote to the Native American Church, however, is required to obtain registration. Okay, so you must be registered if you distribute it, but you don't have to be registered to use it. And so this is a very common sense religious liberty protection for Native Americans. All right, that makes sense. That's perfectly fine. What about, though, if they are working in a drug rehab center, as happened in the state of Oregon? Hence, we got the case, Employment Division v. Smith. It's also called Oregon v. Smith. It goes by both names. So yeah, Al Smith, this guy, and his friend Galen Black, who didn't make any media appearances, Al Smith was kind of the more popular figure in the case, were taking peyote for religious reasons, coming from Native American background. And they were working in a drug rehab center in the state of Oregon. They were supposed to be helping people get off drugs. Suddenly, though, they tested positive, frequent drug tests in these kinds of clinics, and they were terminated. They said, "Oh no, wait! It was peyote. It wasn't like an addictive drug or anything. Peyote is different. It's for religious reasons." And the drug rehab center said, "Sorry, we don't care." They turned around and applied for workman's compensation through the state of Oregon, which they were eligible for if they'd been terminated for a variety of reasons, but not this reason, because technically this was going against the very serious contract that they made with the state that they would not use drugs working in a drug rehab center. Wait a second. We are being denied unemployment compensation because of our religion here. No, maybe it's a religion, but we still regard peyote as a Title I substance. It has to be, or Schedule I substance. If you use it on the reservation and you don't agree to work for a state facility, okay, that's fine. But the fact that they did meant, sorry, they compromised it. What to do here? And so they appealed it to the U.S. Supreme Court. Looking back at that earlier case, Sherbert v. Verner, as well as a variety of free exercise cases that had happened before, and it is accepted by the U.S. Supreme Court. Employment Division v. Smith in 1990. This turns out to be the most controversial Supreme Court case dealing with religion ever. Antonin Scalia actually wrote the opinion, which kind of shocks a lot of his conservative supporters. He's well known for being this original intent judge. He's politically very much to the right. So what happened here? Well, Scalia explains himself. He lays out the facts of the case. He points out that Oregon drug laws as well as federal laws prohibit the use of this substance under the Controlled Substances Act. The Native American tribes are exempt on their reservations, and that's it. Otherwise, it is a Class B felony. So let's consider the case of Alfred Smith and Galen Black. They claim that they have a free exercise right, not just to use peyote and work in a drug rehab center, but then be eligible for unemployment compensation in the state when they are fired. They call this a freedom of, Scalia points out, look, free exercise means freedom of belief. That's perfectly fine. But belief that leads to actions that conflict with the common good as understood by the state, you cannot claim any such protection that way. So, page 227, what does he say? Little below the middle. The government may not compel affirmation of religious belief, right? It can't force you to believe something, it can't stop you from believing something. It cannot punish expression of religious doctrines it believes to be false, impose special disabilities on the basis of religious views or religious status, or lend its power to one or the other side of controversies over religious authority or dogma. That's what the free exercise means. The free exercise clause is a step beyond belief too. So he's going through the layers here. There's belief, that's private, but then there's also exercise, right? To act on your beliefs in the way that you think best. Those too are protected. So no one is going to stop Catholics from taking bread and wine. No one is going to stop Muslims from praying 5 times a day, although we talked about the prison case earlier, that's the exception. So too, no one is going to force worship statues or bow down to a golden calf, for Scalia's examples. But there is a level of exercise that goes beyond all of that that does have a public impact. And if the free exercise rights conflict with what he calls laws of general applicability, if laws are generally applicable, then we have to side with the state. So really, he goes all the way back to Felix Frankfurter here, that the common good is more important than the individual good. The individual is broadly protected by that common good. There's all kinds of rights you can enjoy, but the common good gets to draw the line. So it says middle of page 228, our decisions reveal that the latter reading is the correct one. We have never held that the individual's religious belief excuse him from compliance with an otherwise valid law prohibiting conduct that the state is free to regulate. On the contrary, consider all these precedents. And here's some that we looked at. The Gobitis case. Here he quotes Frankfurter saying that conscientious scruples have not, in the course of the long struggle for religious toleration, relieved the individual from obedience to the law, to general law not aimed at the promotion or restriction of religious beliefs. Although it's unusual that Scalia leaves out the fact that Gobitis was overturned. Still, though, he agrees, obviously, with Frankfurter. Consider the Reynolds case. Isn't this exactly what Morrison Waite said years and years before? That laws are made for the government of actions. And while they cannot interfere with mere religious belief and opinions, they may interfere with practices, in that case, polygamy. So too here with using peyote and working in a drug rehab center. So, Scalia goes on. What is the real basis for the protection of free exercise of religion? Prior to this time, the court had gotten really involved in protecting free exercise all over the place. Maybe not Mormon polygamy, that was back in 1870s anyway, but certainly, remember the Ballard case, the IM movement, right? The court protected him. The court protected the woman in Sherbert v. Verner. And so it had gone to great lengths to protect all kinds of religious belief. But notice, do you have to protect the content of religion itself? Can't you also protect the exercise? And any exercise of religion is going to come out in a way that fits in the broader protections of the First Amendment. So take Jehovah's Witnesses passing out Watchtower magazines. Isn't that freedom of the press? Take any number of religious congregations. Isn't that freedom of assembly? Take a street preacher standing on the corner preaching. Isn't that freedom of just plain old speech? Look at all the cases we've handed down that protects all these other aspects of free exercise without directly protecting free exercise. And so with Oregon v. Smith, or Employment Division v. Smith, under Antonin Scalia's opinion, all the free exercise cases that came before that dealt directly with free exercise were overturned. All the cases that protected free exercise on the basis of free speech or press or assembly or just general privacy, those are fine. That's all the protection that religion could possibly need, Scalia says. The current case fits in with those frameworks. And so we are no longer going to hear cases dealing with free exercise that has to do with the actual content of belief. Now look, if the state of Oregon wants to carve out an exemption for people like Al Smith and Galen Black, fine. But just like Frankfurter said, we are not going to be the ones to force them to do that. It's not up to the court to make such decisions. Hey, several states do carve out peyote exemptions already. If Oregon wants to be one of those states, that's their choice. He says on page 230, it is therefore not surprising the number of states have made this exception to their drug laws for sacramental peyote use. But to say that a non-discriminatory religious practice exemption is permitted, or even that it is desirable, is not to say that it is constitutionally required, and we're not going to say that. And so he concludes, it may fairly be said that leaving accommodation to the political process will place at a relevant disadvantage those religious practices that are now widely engaged in, but that unavoidable consequence of democratic government must be preferred to a system in which each conscience is a law unto itself, or in which judges weigh the social importance of all laws against the centrality of all religious beliefs. But that is simply not what a Supreme Court is for. We've made a mistake over that over the last few years, and we are now going to overturn it. So we come full circle here. Scalia really does restate all the things that Felix Frankfurter said back in the day and brings that back as the guiding principle of law. As we know, as we discussed last time, what happens with this case? This is the motivation for the Religious Freedom Restoration Act in 1993, signed into law by Bill Clinton. The court struck it down later, but then it was reinstated through various state legislatures. And now it currently stands that state courts must continue to apply strict scrutiny when it comes to religious freedom. Not because of the court is out of that business, but because of the states. Is this good for religious freedom? Do we still see it protected? Should it be protected? What does the future of religious freedom hold? Well, it has a lot to do with what the future of religion is in American politics. Let's say the last final words. I will kind of conclude tomorrow, and I'll post it, just kind of my final thoughts on the class and everything we talked about. And I'll certainly open up the discussion board to you guys. I think it's already posted on Moodle. Interested to hear your thoughts about all of this. And we'll sum up the final word on religion and politics, and the quiz will be tomorrow. And I'll talk to you soon.